Precedent, in a sense, if you talk about the thought of misfeasance in public office, there are cases in Malaysia. We've had, in fact, recently we already had about 2 or 3 cases, all right, where the courts have held that the thought the thought exists. And in terms of what sort of relief, I think your question is, what's the end result? You sue somebody, it always has an end result, right? What we call declaration, declaratory relief. Declaratory relief is where we get a declaration in the court saying that a particular public officer has abused his or her power in the exercise of the power, all right, to, for example, subvert the administration of justice. That's a declaration. We could also get orders to restrain these persons from further interfering with investigations, right? So those are orders in the future. Okay, so these are some of the prayers that you can, relief that you can get from court if you file an action against a public officer who is liable for, who has breached his duty and liable for the tort of misfeasance in public office. Okay, I think if you look at our mandate under the Legal Profession Act, particularly Section 42(1)(a), we are mandated actually to take action in the cause of justice, which is in other words means the administration of justice without fear or favour. So if we see that a cause of justice or the administration of justice is in some way being perverted, all right, in some way being obstructed, in some way being subverted, then it's a duty of the Malaysian Bar to take action. All right. Now those actions, and let's be very clear about this, those actions are not because we have come to any conclusion on guilt or innocence. We have not come to any conclusion as to who is guilty or innocent of all these allegations. All we are saying is this: public officers should not interfere with investigations that concern them. They should allow those investigations to carry on, and then the result comes. If it's an exoneration, it's an exoneration. If it's culpability, it's culpability. You deal with it then. But you cannot interfere, sidetrack investigations, right? That's our concern. So I have to answer your question, Hafiz, in a shorter way, when we see there is multiple acts of interference with the investigative process, then what the Malaysian Bar is saying is this: A, the investigative process must be put back on rail, must be restored, because we want a result. B, those who are responsible for it must answer for their conduct and must be prevented from further in the future interfering with the investigations. That, if you like, is the thrust of the resolutions that we have here today. So if you ask me, how does the investigation now proceed? If you look at our resolutions, we have proposed that a Royal Commission of Inquiry now take over and look into these matters. So what does that mean? It means that the previous investigation, there's a problem. They started, there was this interference, and they can't seem to be going anywhere at the moment. So even if they come up with any results, there's going to be question marks about it. Whether or not this is an independent, neutral decision they have made, given what they have gone through. And they've gone through a lot. The MSCC has gone through a lot in terms of arrest, raiding. The BNM officers have been questioned. You have the special branch officers, top 2, one removed, other transferred. So can you really now look at these people? And so let's not forget the AGC. The AGC, the removal of a sitting Attorney General, and arrest of at least 2 officers. 2 officers were arrested. You know that, right? One was the DPP who was seconded. The other was the officer in the AGC as well. So you can see here that these are the concerns that the public have and the bar has. There's interference into all these different agencies which are investigative. In the AGC's case, not investigative. They are more to decide on prosecution. This interference is what we are concerned with, and we want it to stop. The action we take is that it stops, so that there can be a completion, a resolution to this allegations. I would say it is in the interest of PM not to ignore this. Given everything that has happened, this will restore the investigation, and since he claims that he is innocent, all right, then the RCI will give him a chance for exoneration. Will give him a chance for exoneration, right? So he should be supporting this. There's no reason to what is this? I tell you, members of the press, again and again, we have not drawn any conclusion, and please do not misquote me, because that will be a great disservice to the bar. Today was not about who is innocent or guilty. The bar has not come to any conclusion. That's not our role here today. Our role here, as I said, to uphold and restore the rule of law in respect of the investigation. So the investigations will go on, and there will be a finding. All right, we will deal with the finding later. I'm not saying we'll agree with it. We may not agree with it. We will deal with that later. All right, but today is not about who is innocent or who is guilty on this. All right, ultimately. All right, but the fact that there are some people who are guilty in having interfered with the investigations, that we are not happy with. All right, but the allegations, when I talk about allegations, what are you talking about? You're talking about allegations of corruption. You're talking about allegations of breaches of electoral laws, allegations of penal code offences. That's not our concern today. Nobody has come to any conclusion. The bar has not come to conclusion who is innocent or guilty of these things. That comes much later. Investigations must finish. But if you don't have investigations, how to have a resolution? Isn't it? That's the problem. Okay. So ours is a principled position. It's a rule of law position.